2006, $200. Francis Jones for calendar year 2008, $100.
Before I accept a second, inasmuch as they are separate and there are different penalties for different years, is there anyone who wishes to discuss them individually? If not, then is there a second to the motion for both Mr. DeLuca and Mr. Jones, a fine for the first of $200 and for the second of $100?
Second.
And it has been second. Any further discussion? If not, all those in favor, please say aye.
Aye.
Are there any opposed? There being none, that passes unanimously again. And the next matter on our agenda under the Gaming Act, Commissioner McCurdy, I believe you have the Sturgeon determination.
I do, Mr. Chairman. He said is he expected to be here?
He hadn't indicated, so no one way or the other.
I'll proceed with my name. The requester is Thomas Sturgeon. Mr. Sturgeon is a former employee of the Pennsylvania Gaming Control Board, which I shall refer to as the board. From April 1st, 2007 to December 30th, 2009, Mr. Sturgeon was employed by the board as the Director of Casino Compliance. Mr. Sturgeon's duties and authority as Director of Casino Compliance included: 1, having ultimate responsibility for the functions and performance of the Bureau of Casino Compliance; 2, supervising the casino compliance representatives and their work product; and 3, working closely with attorneys from the board's Bureau of Investigations and enforcement on all enforcement actions. Mr. Sturgeon retired from Commonwealth on December 30th, 2009. After he retired, Mr. Sturgeon returned to work for the board in 2010 as an annuitant. Mr. Sturgeon has stated that there were no documents defining his duties and authority as an annuitant. However, he states that his duties and authorities as an annuitant are limited to assisting the board with hiring employees, including casino compliance representatives, and specifically interviewing and performing background investigation duties as to such prospective employees. Mr. Sturgeon has requested a determination regarding certain post-employment restrictions of the Gaming Act. Mr. Sturgeon asks whether he would be restricted for a period of 1 year following his retirement from working with an entity that has applied for a gaming license in Pennsylvania. Mr. Sturgeon states that his view that he would be subject to such restrictions for a period of 1 year. Additionally, he asks whether his return to work for the board in 2010 as an annuitant would result in the applicability of the restrictions for a longer period of time, so as to extend the time before he could seek employment or consulting work from such a gaming entity. Chairman, before we hear any parties, I would point out that because Mr. Sturgeon was an employee of the board, our review of this matter must consider both sections 1201H(13) and section 1512A(1) of the Gaming Act. This would be an appropriate time for any interested party to speak on this matter.
And we call to the audience if there is anyone. And there being no one appearing or requesting, back to you, Mr. McCurdy.
Thank you, Mr. Chairman. I reviewed the facts and relevant statutory provisions. It's my view that Mr. Sturgeon's duty as Director of Casino Compliance substantially involved in enforcement under the Gaming Act, and Mr. Sturgeon was an, quote, executive level public employee, end quote. Therefore, it's my view that upon retiring on December 30th, 2009, Mr. Sturgeon became subject to the restrictions of section 1201H(13) as set forth in Act 135 of 2006. Additionally, as a former, quote, executive level public employee, unquote, Mr. Sturgeon would remain subject to the restrictions of section 1512A(1) of the Gaming Act as set forth in Act 135 of 2006 for a period of 1 year following his retirement. As for Mr. Sturgeon's duties as an annuitant, they are so limited that, in my opinion, they would have no impact upon the duration of the restrictions. Finally, I believe it is clear from the face of the restrictions that during the first year following his retirement, Mr. Sturgeon would be prohibited from accepting employment with or being employed by an entity that has applied for a gaming license in Pennsylvania. However, we cannot answer Mr. Sturgeon's question regarding consulting work without actually interpreting the restrictions as set forth in Act 135 of 2006. I believe we lack jurisdiction to interpret the restrictions, and Mr. Sturgeon should consider obtaining legal advice in that regard. Giving my analysis, I'd like to make the following motion. I move that holding of this commission in this matter be as follows. upon retiring on December 30th, 2009 from his position as Director of Casino Compliance for Pennsylvania Gaming Control Boards, Mr. Sturgeon became subject to the restrictions of Sections 1201H13 of the Gaming Act as set forth in Act 135 of 2006, Section 2. The restrictions of Section 1201H13I would apply to Mr. Sturgeon for 1 year following his retirement. Restrictions of Section 1201H13 II would apply to Mr. Sturgeon for 2 years following his retirement. As a former executive level public employee, Mr. Sturgeon will remain subject to the restrictions of Section 1215A1 as set forth in Act 135 of 2006, Section 10, for a period of 1 year following his retirement. It is clear from the face of Section 1201H13I and Section 1215A1 that while the restrictions of those sections would remain applicable to Mr. Sturgeon, he would be prohibited from accepting employment with or being employed by an entity that has applied for a gaming license in Pennsylvania. The Commission lacks statutory jurisdiction to interpret the restrictions of Section 1201H13I, Section 1201H13II, or Section 1512A1 as set forth in Act 135 of 2006 to determine whether the restrictions would apply with respect to consulting work. Based upon the submitted facts, Mr. Sturgeon's limited duties and authority as an annuitant would have no impact upon the duration of that applicability of the course of that restrictions to him.
And with that motion, is there a second then?
Second.
It's been seconded. The forum is open for any comments, concerns, questions?
I need some help. Pardon me?
Mr. Fryman, when Mr. McCurdy was reading, he said section 1215 instead of 1512. I just wanted to make, we know what it was supposed to be. I just wanted to make sure for the record there.
Correction is noted and accepted. Thank you. Mr. Bolton.
This is new for this commission, the gaming law, and so somebody applies and we give them an interpretation, but we say we can't interpret what he does when he's a consultant. He agrees that he can't do anything after the first year, and then we say, well, maybe you should seek legal counsel. I don't think I'm having trouble with that. What happens if we would interpret what happens when he does a consultant?
Mr. Chair, I think at that point you would be exceeding your jurisdiction under the Gaming Act. We're used to the Ethics Act, where your jurisdiction is very broad, and you can issue advisories actually telling people what their responsibilities are under the restricted activities and conflict of interest sections. You can actually tell them what they can and cannot do. In the Gaming Act, it's worded very differently. You are not authorized to issue advisories, but determinations of whether certain restrictions apply to the requester. You have not been given the authority to actually interpret what those restrictions would mean in a particular fact situation. So if something is clear on the face of it, there's no interpretation required, you can say that. I think, for example, as Mr. McCurdy's motion says, you can say that when he retired, the restrictions applied for 1 year. That's clear. There's no interpretation required.
And he agrees to that.
But he asked not only about employment, but with a casino or a gaming license applicant, but he asked about doing consulting work for them. And if you...
After that year?
No, even during. So when you look at the wording of these sections, it talks about accepting employment, no former board